Everybody's Christopher Small, owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about how to avoid how to avoid probate without the use of a trust. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay. How to avoid probate without a trust. This is a question I get asked fairly often. It's a question I have, all right, it's something I answer in almost every potential client meeting. And before I get to that, I want to really just point out that not everybody needs a trust. If your only intent, if your only sort of goal is to avoid probate, you can often do that without a trust. This is whether you're in Washington State, in California, in Texas, in wherever. There's a good chance that you don't need a trust if your only goal is to avoid probate. Now, there are often other things that get in the way of your goals that sort of require or can be really helped out by a trust. For example, with the things that I'm about to talk about, you can only do direct distributions, which means you are going to give these assets to whomever you want to give them to without restriction. They are just going to get them, they're going to have them, they're going to keep them, and you can't do anything about it once you give the things to the people, okay? But if you just want to avoid probate and you don't care about what people do with the things when you give them to them, then try these things, okay? So the first and foremost is beneficiary designations need to be completed on all of your accounts, retirement accounts, investment accounts, life insurance policies. These are going to be called beneficiary designations. Who are going to get these things when you're gone? Now, another way to do this potentially, this really going to come, I'm going to talk about it until we get to the other place. When you do beneficiary designations, you can add multiple people. You can do different percentages. There's a lot of sort of flexibility with how you want to structure those distributions amongst different people. So you could say like Sally gets 20%, Tom gets 50%, whatever you want to do. Then when you die, people will just literally take the death certificate to the financial institution. They will cut you a check. That's how it goes. That's number one. Number two, checking account and savings accounts are going to be distributed with something called a transfer on death designation. It's exactly the same as a beneficiary designation. It's just a different name. Now, when it comes to checking and savings accounts, a lot of people will think, oh, I'll just put somebody on the account as a joint account holder. Then when I die, they'll get the account. That is true. There are other unintended consequences though by doing that. So I would suggest, like, unless you're married and really want to share and you're sharing everything, I would not put another person on the account. They can be a signer on the account. You can do a power of attorney if you want them to be able to help you with the account, but don't put them on the account. Transfer on death, it will go to them when you die. Okay, that's the second thing. And then number three, the thing that hangs people up the most, with real estate, you don't need a trust necessarily to transfer real estate. In Washington, for example, you can do this in Texas as well. You can do it in California, I believe, as well. I'm just naming like big states. I don't know all the rules in all the states, but a simple Google search would reflect this. Something called a transfer on death deed. Basically just says when I die, it's a recorded instrument, so you record it just like you would any other real estate transaction. It says when I die, I want the property to go to this person. When you die, they basically just record the death certificate, boom, it goes to them, okay? Now, when would you maybe want a trust to avoid probate? Only a couple situations. Situation number one is going to be if you own like a business, an LLC, if you own shares of a C Corp, that's a closely held business, then you're probably going to want to use a trust to transfer those shares. There's no beneficiary designation or transfer on death designation for that. The other thing to consider too is if you own real estate in multiple states and one of those states does not allow you to do a transfer on death deed, then you are going to want to consider doing a probate for that, just to be able to transfer that property without having to go through the process, okay? That's it, pretty straightforward. So avoiding probate is possible. Again, there are other reasons why you might want to have a trust. I would suggest that you talk to somebody. If you're curious about what those things are, you can talk to us if you want. The way that you do that, if you want to, is go to cmslawfirm.com. Talk with us over the phone for free, and we'd love to do that for you. Otherwise, that is it. If you like this video, hit the like button. If you know someone needs to hear it, share it with them. If you have a question or comment, leave it. I will answer it. And as always, I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. Appreciate you. And I will talk to you again soon. See ya.